Hello, everyone, and welcome to the next monthly Immigration Litigation Roundtable with the Amica Center for Immigrant Rights, formerly CARE Coalition. We're very excited to have our first roundtable with you all with our new name. In case you didn't hear yet, in one of the prior roundtables, CARE Coalition recently changed our name in honor of our 25th anniversary and to reflect that we're no longer just based in the capital area, which was part of our former name. Amica stands for, the short version is Amica Center. And Amica is Latin for the word friend. This is really how we view our work, fighting alongside the clients we work with who are at risk of detention and deportation. And we're very excited to have you all here to discuss a watershed case that came out at the Supreme Court recently, Loper Bright, which really upended Chevron and deference to administrative agencies under the Chevron standard. So we're going to go ahead and get started. And I just want to say a few housekeeping things while I'm admitting people as we go. So we like these roundtables to be informal. We really intend to provide, a short, valuable presentation to give you all some tools to support your work. But we want to also provide a space for you all to connect and brainstorm on litigation strategies. Given how new this case is that just came out, it's very important, I think, to allow folks to have space to connect and share ideas and just want to manage expectations. Our insights we'll be sharing today are very preliminary. There's more to come. We're still digesting this decision. I think there's a lot that we probably can't even anticipate at this moment that will come out of this decision in the years and decades to come. And I'm very thankful to my colleague, senior attorney Austin Rose and Daniel Malo, who were willing to put together this presentation after how quickly this came out and share some initial key insights that we're excited to share with you. Before we jump in, a few quick words on the program that we work in called the Immigration Impact Lab at the Amica Center. This is where we house our impact litigation and a lot of our advocacy work at CARE Coalition. We respond to failures in the immigration system by strategically appealing cases, developing impact litigation, and launching advocacy efforts that have the potential to transform the system and establish new legal precedents for immigrants nationwide. I should say my name for those who I'm connected with, I'm Adina Applebaum. I'm the program director of the lab, and we host these free monthly roundtables in order to connect with you all. We really want to be supporting others who are litigating around the country, providing resources for you all, and collaborating on cases. If you do have any cases that you would like us to take a look at, feel free to refer them by just emailing lab@amicacenter.org. And then finally, how we think about impact litigation. We're very focused on the ground up, given that we're based in a direct services organization. Most of the work of Amica Center is direct services removal defense for adults and children. In the lab, we create impact and new precedents one case at a time. So most of our cases are individuals removal proceedings that go up on appeal, starting at the IJ level and going to the board and the circuit courts. We also do increasingly more and more work in district court, primarily habeas petitions. We also do class actions, and those also have the potential to go up to the circuit court. So that is how we're able to make impact on a more national level with precedents that affect many people, as well as our national level cases. So with that being said, I will turn it over to Austin and Daniel to get us started. And please do add comments and questions in the chat as
Thank you, Dina, and thanks everyone for being here. So as Dina said, we're going to talk about very preliminarily what the overturning or the overruling of Chevron means for us in the immigration space. And I want to say at the outset that this is unique to immigration, and we're in this interesting situation, which I think a lot of the overturning of Chevron is unfortunately going to have some devastating effects in a lot of areas, whether that's environmental or financial regulation. So we want to acknowledge that. But at the same time, it does provide some openings and some very potentially exciting ones for our work in immigration in terms of not needing to defer to unreasonable interpretations of statutes in the immigration context. So we're going to talk about the opportunities in the immigration space, while of course acknowledging that there are plenty of downsides outside the immigration space or potentially within it. So the way we will do this is talk about the Chevron standard very briefly, that I think some folks are already aware of, how it was overturned in Loper Bright, recent Supreme Court decision. And then I'll turn it over to my colleague Dan to talk about some preliminary litigation targets that we have identified post Chevron or post Loper Bright, however you want to say it, and then open it up to some group discussion so that we can talk about this and strategize alongside you all. And Adina might jump in with some questions as we go. So what is the Chevron doctrine? It was a watershed decision in 1984 centering on EPA application of the Clean Air Act. So that the Environmental Protection Agency had applied the Clean Air Act in a very technical way in the context of environmental regulation. Chevron, the company, had challenged it, that application of the EPA, and this Supreme Court decision came out that established the Chevron standard. And basically it's a standard for how agencies should receive deference in their interpretation of ambiguous congressional statutes. The idea behind it being that the agencies have the expertise, and so they should get the ultimate say on how to interpret vague statutes. So the two-tiered test, which is not always followed to a T, but the basic concept is, first, is the statute ambiguous? If there's a clear way to read the statute, then we don't even get to agency deference. But is it ambiguous? And of course, courts had very different understandings of what's ambiguous. And then if it is ambiguous, then is the agency's interpretation at least reasonable? It doesn't have to be the correct one under the standard. The court could think there's a better interpretation of two or more interpretations, but as long as it was reasonable, the agency got deference, and that's what was applied. So this, of course, led to agency deference in environmental, financial, and immigration regulation context. And over time, Chevron was really chipped away in a lot of ways. So, for example, finding statutes unambiguous so that there was no deference in the first place, or what's considered reasonable. But at the same time, it was often applied even beyond its original terms. And one example, which I think will be relevant to what we'll talk about, is a decision called Brand X. Pretty complicated decision. It applied Chevron in other ways, but one of the things it said is that even in the following unique situation, which I'm going to describe, deference still applies. And that's the situation where a circuit court adopts an interpretation of a statute, and then an agency after the fact decides to adopt a different interpretation that's inconsistent with the circuit court. So you would think that that would be barred, that the agency couldn't adopt an interpretation inconsistent with the circuit court. But under the Brand X test, as long as there was some ambiguity in the statute reflected in the original decision, that agency interpretation is allowed to stand, and effectively it allowed agencies to overturn circuit courts in a way, right? To say, we are going to adopt a different interpretation of the statute, and then they would sometimes get deference under Brand X for that interpretation. And that'll be important as we talk about what we can do going forward. So the Loper Bright decision, this is a very simplified summary of it. So I encourage you to read it, and including the dissents by the liberals. So effectively it was a 6-3 decision, mostly on ideological lines, 6 conservatives voting to overturn Chevron because of their distaste for the administrative state, and the 3 liberals voting to uphold it because they believe the agency should receive some deference on technical issues. Justice Roberts wrote for the majority, said that the Administrative Procedure Act, which kind of grounds review of agencies, it doesn't actually say, by its plain terms, according to him, that agencies should get any deference when it comes to statutory interpretation. So therefore, Chevron was wrongly decided. And there's a lot that led up to this decision, a lot of politics behind it. Justice Gorsuch, who's notably hostile to the administrative state, wrote a very strongly worded concurrence in which he actually gave some examples, which I think are helpful for us going forward in the immigration context, or at least one immigration context. And he was talking about the negative impacts on Chevron on individuals' lives. So he cited a case that he had decided in the 10th Circuit when he was a circuit court judge, Denise Robles, where he felt like he had to defer to the agency under Chevron, under then governing law, because you're a circuit court judge, even though he didn't want to, right? He didn't think it was the right interpretation of the statute, but still had to defer to it. And it had to do with something they got it, the judges in the circuit got it not prospectively applied, or not retroactively applied, but it still could be applied prospectively, this new agency interpretation. So that's just an example of something that would not have happened absent Chevron and won't happen now that Chevron is ended. One very important point, and we're going to talk more about this, is that there is some interesting language in Roberts' majority decision. And it basically says that stare decisis still applies. That's the principle that, law that is, especially at the Supreme Court level, if there's a decision, then that decision should receive some weight, and we can't just go around overturning previous decisions without a substantial reason. And so he said stare decisis still applies. So, quote, we do not call into question prior cases that relied on the Chevron framework. Mere reliance on Chevron cannot constitute a, quote, special justification for overruling such a holding. So I think this language is going to be the subject of a lot of debate. The way we read it very preliminarily is that there's no automatic right to challenge all decisions that apply the Chevron framework. But in particular cases, I think there is more room than in others to overturn previous decisions that receive deference or new ones. And we'll talk about that on the next slide.
Thanks, Austin. And quick question for you. While we're talking about stare decisis, kind of the inverse of that going forward, even if the Chevron deference is now not required, do you think informally courts are going to still defer, given that we see the courts tend to be leaning toward going against immigrants in these cases?
That's a great question, and I think one that we won't know for sure. I think certainly the hostility of federal courts, or some federal courts and some federal judges, to immigrants will continue, and there will always be implicit bias and implicit hostility that's baked into decisions. I mean, I think that though for other judges, there are going to be opportunities here, because I think if you look at past Chevron cases, there are a lot of cases that you can see, and the circuit court's pretty clearly signaling that absent Chevron deference, they would have ruled for the immigrant because they think that that's the better interpretation, but they had to defer. And I think in cases like that, then there might be a difference. So we just don't know for sure whether there'll be that implicit. And I will say, Dan will get in more into this, like Chevron makes more sense in the context of environmental regulation, for example, because the idea is that the agencies like an EPA has a substantial scientific expertise that judges do not. It makes substantially less sense in our eyes for immigration, because the BIA, for example, is not an expert on criminal and immigration law, though they'd like to say they are. And so to the extent there's any implicit deference, it doesn't make any sense to defer to administrative judges in this context. So what can we do now? And again, do not hold me to this. This is just preliminarily what we're thinking in terms of what's going to be the most feasible to do in terms of progress post Chevron, and what is going to be the most difficult to do. It doesn't mean that we'll definitely be able to succeed on the most feasible, or that it's not at all possible to do the least feasible. So what we can pretty surely do is, with renewed freedom and vigor, I think we can mount new challenges. So things that it hasn't been decided by a particular circuit court, right? There's been no decision saying we are deferring under Chevron to this interpretation. It's, for example, a BIA precedent that has not been challenged in a particular circuit. That I think we can take up to the circuit courts, and we might, it's not a guarantee that we will win, but we will not have to face explicit deference for those things. And so if there's a clearly better interpretation of the law, then I think we are going to have a lot more success with that than in the past. So those are new things that there have not been circuit court decisions on. And for that reason, I think it's probably going to be the case that it's going to be easier in circuits that don't have much immigration precedent, because then there's going to be fresh issues that have not been ruled on previously. That's not always going to be the case, but that's just something to look out for. And then what's the next most feasible is, and this is a quirky thing that has to do with Brand X, and this is speculative, but the idea is if we do have a Brand X situation where a circuit court ruled one way, they adopted one interpretation, and then the BIA went, and I'm using BIA as an example, it could be other agencies, but that's a common one that you take up to the circuit court. If the circuit court ruled one way, the BIA ruled another way, then if we go and we challenge that BIA ruling, we can look back to the original circuit court ruling and say, this is what the circuit court decided before they had to defer under Chevron. This is what they clearly thought was the better interpretation. And now that Chevron is over, right, then we can go back to that interpretation. We already know to some extent that absent Chevron, this is how the circuit court would have ruled. In addition, the way Brand X is often applied, it ended up being more deference applied to the agency than Chevron even calls for. So I think those two factors combined make it easier to challenge agency interpretations of the law in that context when there was a previous circuit court interpretation. This is not particularly common, but just some basic examples are Fernandez in the fourth, Linares or Atia in the second. So to give more concrete example, Fernandez, I believe, was about or Linares or Atia was about the 1 year filing deadline, and the Second Circuit had ruled that leaving the country in a certain context did not affect the 1 year filing deadline for asylum. Then the BIA adopted a different interpretation. If we went back, if we challenged the BIA's interpretation, we would say to the Second Circuit, look, this is what you ruled before the agency adopted this, so we should go back to this because there's no more Chevron deference. So that would be an example. And then finally, I think what's going to be the most difficult to do, but not impossible, is when you do have a circuit court decision that it did go up and it said, we are applying Chevron deference, right? And we are going to defer to the agency interpretation, and now that's the law, right? That's what the Loper-Bright decision said we cannot do as a matter of right automatically. We can't just overturn it simply because Chevron has been overruled. That's not to say that we can't do that, though, right? For example, if the Chevron logic was kind of flimsy, and if what the Chevron deference that BIA precedent or whatever precedent received was actually more than what Chevron called for, then that could be an example. How ambiguous was the statute? Was it a close question? Was the circuit court really signaling that they felt there was one clearly superior interpretation? If that's the case, then do we have more freedom to say this is the right one, right? And so I think that's how we should think about this in terms of what's the ripest for review, these fresh new things, and then going down the totem pole to things that are going to be more challenging.
Thank you, Austin. This cascade is really helpful, I think, to give people a framework to start thinking about these cases. I want to pause for a moment and see if others who are live, I know we have currently 209 people here live. Thank you so much for being here. Does anybody want to share in the chat or come off mute for a moment and share some thoughts on what opportunities are available? And if you're listening to the replay, we want to hear from you too. You can email us always at lab@amicacenter.org. Anybody have some thoughts? Is this like resonating with how you all have started thinking about it? Or if you have been like, I have no idea where to even start thinking about it, that would be helpful to hear too. Want to hear your experience. I know in the chat there's been a couple suggestions already. Someone asked if, oh, thank you, go ahead.
Yeah, this has been, I agree with everything that Austin said in his presentation. One other thing to keep in mind is related to the stare decisis issue, whether cases that were decided under the Chevron framework remain binding. going forward. And I read that language in Loper Bright to suggest that they do, absent maybe some additional argument as to why it doesn't, like a Brand X situation that Austin mentioned. But another thing that I think that a possibility that this raises, which is troublesome, is that not only would a prior circuit decision that deferred under Chevron, not only would it be binding on other panels in that circuit, but it could also be binding on the agency itself. And in other words, the agency's prior position would be locked in. I mean, one kind of benefit of Brand X, the prior Brand X framework, was that the agency, if it ruled one way, maybe under a bad administration, there was always hope that it could change its mind under a good administration. But now, if we had a bad agency interpretation that a circuit deferred to, then arguably the board itself would be locked into that position going forward. On the other hand, the converse could also be true. If there was a good agency interpretation that a circuit deferred to, then arguably, the agency would be locked in that way as well. So I think that this is something, typically Chevron only comes up when we're litigating in federal court, but I think this is something that people should also keep in mind when cases are at the board. And maybe previously you would have been able to ask the board to overrule a prior precedent, and maybe now going forward, the board arguably wouldn't even be able to overrule a prior precedent if a circuit that deferred to that precedent. So just something to keep in mind.
Thanks, Ben. I appreciate you weighing in on that really helpful point. Lori, I'm wondering if you, Lori Rosenberg, want to share what you put in the chat. I don't know if you're able to go off mute where you're at today.
Sure, I can do that. Yeah,
Thank
I was
you.
going to say that, I think we should talk a little bit about what Skidmore deference is, and just the fact that reasonableness still is a touchstone. And one of the cases that I think is somewhat valuable in including an agency's point of view is the decision of the court written by Elena Kagan, Kaiser versus Wilkie. And because I think that decision actually made a lot of sense in talking about what the heck is ambivalence, what does that really mean, or ambiguity, and how you really look at the agency's expertise and their position to be able to be offering an interpretation. I mean, I think that I, for a long time, have believed and hoped that we could get rid of Chevron in the immigration removal defense context anyway, because I think there we've faced agency decision makers who have been really unreasonable from our perspective. And from the perspective of, reading the language. I used to joke about the fact that I agreed with Scalia half the time. But I do think that when you look at the broader implication politically of what this means, it is really troublesome, as your first speaker said, when you're looking at it from the perspective of some of the agencies like EPA and, other agencies that rely on, even FDA, that rely on medical or scientific expertise. So I think all of what I'm saying here is that it'll be interesting to see exactly what the federal circuit courts of appeal are willing to do. I know that I remember years ago, they were actually quite willing to say, we have expertise in criminal law, and so why should we be deferring to the BIA, for example, when we in fact decide criminal cases all the time, and we certainly have the expertise there. But I still think that there will probably, my guess is that there will be federal judges who still are a little nervous about actually coming out and stating something that they are going to advocate for from their perspective. I still think that, the courts are going to still be a little reticent to simply go with whatever we offer as opposed to what the agency might have to say.
That's a great point, Lori. Thank you for raising it. Might have a playback. Sorry. I was getting repeated. Yeah, I think that's a great point. And I'll just point out, because you mentioned Skidmore, which we didn't talk about. So what Lori is referencing for others is that effectively the court has said what will replace Chevron deference is a much lesser deference called Skidmore deference. And it's a little unclear whether Skidmore deference is really deference at all. It's basically whether the decision was reasoned, not reasonable. Like, did they have a legitimate process for reaching it? I think that might be helpful. The Skidmore deference might be helpful in the context potentially of an EPA decision where it's like complex science that goes into it. I have more trouble understanding about how, and you're probably right, Lori, that there still will be some deference to agencies and immigration agencies, but it's hard to imagine what Skidmore deference would really mean in the context of like a criminal immigration question, right? What does it mean to make a reasoned decision in that context? And I think that's actually segues well into what Dan is going to talk about.
Thanks. Yeah, these are great points, and I'm glad that other folks are bringing them up. It ultimately now sort of pivoting a little bit to, rather than where in the procedure we think that there's the most impact, we started to try to think about topically, like what has the most fertile ground. And yeah, naturally came to, a lot of the crime bars and grounds of inadmissibility, deportability, in no small part for the very reason, Lori, that you pointed out, right? That federal judges deal with this all the time. The categorical approach that we apply in this context is taken from ACCA, from that series of cases, right? So in so many ways, this is already essentially squarely within federal circuit courts, in particular's bailiwick, and it makes sense to push that line of argument here especially, and maybe makes this the areas that are perhaps the most vulnerable to inserting a new or better interpretation of what might be a crime involving moral turpitude or not, where an offense falls on the PSC line. So all that's to say, right, is that I do think that we have some room here to push this stuff forward, in no small part because federal courts have already decided that they're not necessarily going to give the agency the same level of consideration on these narrower particular questions in immigration. So again, there's obviously the notorious ambiguity of what is a crime involving moral turpitude. I have yet to actually hear a coherent definition in all this time that doesn't become rather circular pretty quickly. I think, again, it's not that Loper Bright suddenly says every CIMT decision or every PSC decision, is completely undermined, right? But I do think it is an offering, and to the extent that the Supreme Court's remand, I think somebody else noted in the chat, a number of cases across a number of different circuits that had these issues pending before the court got remanded to be reconsidered by the circuit courts in light of Loper Bright. So I do think that there is an opportunity here. We'll talk about in the next slide sort of how eventually I think that gets narrower and narrower as we get closer to what sort of does seem to fall squarely within the agency and the executive's power and understanding of immigration. But nevertheless, here, I think everything from the Silva Trevino and Jimenez Cedillo sort of extra statutory applications of things, again, to fall in the CIMT context, in COAID offenses, there's the difference between the deportability ground versus the admissibility ground, and is that possible? And again, those are just, can someone commit a CIMT for a conspiracy to commit a CIMT kind of arguments that ultimately don't have a really strong, in the BIA's view, right? They've ultimately had to kind of cabin those within their own precedent and understanding, and don't necessarily square very readily with the statute. Next slide, please.
Thanks, Dan. Just to jump in, on CMTs, I know we were starting to talk about with like the prior CMT void for vagueness arguments that many of us used to make, and what this is going to look like now if circuit courts can actually somehow try to interpret this term and not defer to the BIA case law. And it makes me think too of the question Rachel raised in the chat: is this going to result in even more disparate law across the circuits? I know we were anticipating that there could be completely different regimes happening in each circuit now, and that does seem to be something possible. Do you have any thoughts on any of that?
Yeah, to the extent that it is reading tea leaves, and I kind of think it is, I do think that we're going to see a lot bigger disparities as between the circuits, at least in part because, again, if none of them have to pay attention to the BIA and to Ben's point, right, if the BIA gets increasingly locked into particular interpretations in different areas, I think, yeah, we are going to see fairly wide swings. And it would be consistent, honestly, with what Loper-Bright really stands for, which is a reallocation of power from the executive to the judiciary, right? That's my reading of it ultimately, is that we're shifting power, right? So to the extent that judges take that seriously going forward, I do think that especially on those key questions around immigration and some of those very vague terms, we are going to see some really disparate decisions across the circuits. So picking up on some of the fear-based, and I see some folks have already put this out in the chat. Again, there are these terms that have been notoriously ambiguous that I think we once again sort of have a shot at redefining the contours of, whether that's the particular social group, nexus, or even extreme and unusual hardship. Again, these terms sort of tend to skew more closer to things that are only found in our line of work, and so may fall closer on a deferential line when it comes to Skidmore. But all that's to say is, again, I do think that we have an opportunity here to push new definitions, new ways of seeing these terms and what they mean in this kind of new textualist era of interpretation that has been foisted on us. I really quickly, sort of just as an aside, Austin alluded to this, right, is obviously we're talking mostly about the BIA PFR context, but the truth is that, all, as best as we can tell, everything's open up now in a lot of ways. So whether that's CBP, ISU, SCIS's, interpretations, applications, or misapplications of the INA, someone's bond eligibility, the applicability of a particular waiver, what constitutes an admission, things like that we've, slowly tried to tease out between the agency and us. Again, there's an opportunity there, I think, to push back on anything that doesn't fall squarely within the text of the statute, which this court seems to indicate over and over and over again that it's going to at least try to press upon agencies going forward. So final quick thoughts is, obviously keep in mind the DOJ actually has been moving away from Chevron deference in the immigration space, and the Solicitor General arguing a number of the most recent cases at the Supreme Court noted, or has been pushing this line of argument that 8 U.S.C. 1103A essentially gives them that express Chevron deference in the statute, right? That they have a delegation of authority, so they don't need Chevron, that this courts should be deferring to them anyway. There's great resources out there explaining why this is just an incorrect interpretation of that particular section. But ultimately, sort of cutting the other way against that is that there's long held SCOTUS precedent, right, around the rule of lenity that ambiguities in the deportation statutes in particular are to be construed in the non-citizen's favor. So, combining that with Loper-Bright, with Wilkinson, I really do think that there's an opportunity here to try to tackle not just review of mixed questions of law and fact and actually getting the judges in there to look at things, but ultimately an invitation to redefine the other side of the equation as well, which often has been left to the agency to decide whether or not this is extreme and unusual hardship or a particular social group. It's like, no, we actually are being told we can push new and different things forward. That's not to say that there's going to be clear winners, and I don't think that we're going to get a radical upheaval of immigration law through this, but I do think this, again, uniquely posits some opportunities that we haven't had in a long time. All right, so now we come to our sort of just general open air brainstorming section, and we really do invite folks to come off mute, speak up, toss your questions in the chat. Ultimately, these were just our initial sort of takes. We really do want to try to get a community brain power behind addressing this.
Thanks so much, Dan and Austin. This was awesome. I know we've got some questions coming up in the chat. Does anybody feel particularly passionate about speaking about something they've put in there for the group? I'm interested in particular in Rachel's question about the BIA, the AG precedent's going to be meaningless potentially now. And I know Lori's asking, how do people think DHS counsel will argue versus our challenges in circuit courts?
The DHS question is interesting. And I think Ben raised a good point that in theory, we could, before the agency, say you should adopt a different interpretation. I think the whole Chevron framework doesn't really apply as much when you're still within the agency, right? Because, you know, the immigration judge, for example, is still going to apply what the BIA says, regardless of whether we say that the BIA is wrong, right? Whereas when we get to the federal circuit court, that we're trying to get them to overturn. But I think to the extent we say before the BIA, for example, this standard is wrong. I don't know if that will then force DHS's hand in defending the standard, and how they would do that. I would suspect they would not be particularly prepared to do that, but I'm just not sure.
Which I guess brings up a adjacent and kind of odd quirk of immigration laws, that it is for at least that BIA pipeline, that is a one-way street, right? So if we get good decisions at the BIA level, DHS can appeal it to the circuit courts, right? So in a way, right, it is a one-way valve for us going forward. It's, again, not revolutionary that way, but we have an opportunity, I think, to trap some of the good and overturn more of the bad.
I'm curious, Dan and Austin, if there's any particular issues you're most excited about challenging from what we've talked about so far.
Heck yeah, I am. So, you know, I'm mostly involved and interested in federal district court litigation and detention. And so I think one thing we've been really preliminarily kicking around is a matter of MS and bond eligibility. So there's this notorious 2019 decision that overruled a prior BIA decision. So we've got the BIA coming out two different ways in two different administrations. And it was about essentially saying that anyone designated as an arriving alien at the border who goes through expedited removal is not going to be eligible for bond, only parole, even if they subsequently enter, you know, full proceedings. They pass their CFI and enter full proceedings. It's a completely ridiculous rule that doesn't make any logistical sense. And I think that is ripe for challenge. I think it's a little bit interesting because it's not necessarily going to be a PFR in a traditional sense since it's bond, right? But that could theoretically go to the federal district court, right? And we wouldn't have to defer to this silly interpretation. And we could say, you know, no, these people are statutorily entitled to bond in certain circumstances. So I think that's something I'm excited about.
Awesome. Thanks for sharing that. What about for you, Dan? Anything on your wish list?
Honestly, I haven't had an opportunity to fully go after it, but the inchoate differences between the inadmissibility and deportability statutes, I don't know if it's a winner, but I think the statutory text is very clear that there's a distinction there, and one that circuit courts have long to just defer to the BIA on, that they don't need to.
For sure. I know we started talking a little bit yesterday about for cancellation, the hardship standard potentially would be really fun to bring down a bit because that affects so many people.
Yeah, and I think that's the way that Wilkinson intersects really interestingly with this decision. Wilkinson was a decision about mixed questions of law extended It was one of the very few good immigration cases recently at the Supreme Court, right? It extended Guerrero-Lasprilla and said, certain questions are mixed questions of law and fact, and therefore courts have the ability to review them. And so we now, through that, can get more judicial review in the first place. And then once it's a mixed question, it's a question of law, really. And then we can try to get a different standard, for example, for unusual hardship. We don't need to confine ourselves to the BIA's interpretation of what that means, right?
Amazing. Does anybody else listening in have some they're excited about? I see a question Sylvia just asked about if there's more inconsistency in the circuit courts, won't that potentially result in more Supreme Court certs to resolve discrepancies? That's what we were thinking as well, which will lock in the good decisions, but also lock in the bad ones for likely longer periods of time. Not sure if there are thoughts on SCOTUS making more final decisions in the immigration space with this current court makeup. Yeah, it's definitely a concern. And it just makes me wonder like how hopeful we can be, because I think circuit courts will be inclined to still find ways to decline these cases when they want to, So yeah, do you all have thoughts on that one? More cases at SCOTUS?
I mean, like Dan and I or everyone?
Yeah, you,
Yeah,
anybody?
I think we can agree that we don't want things before SCOTUS, this current SCOTUS, right? I think I don't think unless in certain circumstances, we should avoid taking it to SCOTUS, but unfortunately the government can take things to SCOTUS, right? And so, yeah, I think that's totally a concern. Yeah.
Yeah. And I see Angela sharing in the chat, like this is making her more worried about litigating in the eighth. So I totally understand that in circuits that might not be so great on immigrants' rights, that we could be seeing worse law developing that will impact more people. So just kind of a call to action for everyone to think about. And part of why we wanted to just get folks together is it's more important than ever that we collaborate on these cases and support each other. So we really hope for this space to be somewhere where we can do that more and more. So bring cases to us where you need support, and where amicus would be helpful, and especially going into the election with, seeing what administration we're going to have, of course, even more important. So definitely, you don't have to be in an impact litigation shop to work on these issues. Like this is playing out around the country. And if anyone has ideas like how we can be more supportive, what resources you need to hear, ways we can help bring you all together more, please do always share your ideas with us. Again, the easiest way to share ideas and referrals, lab@amicacenter.org. In terms of resources for today, we don't have a model briefing on this issue given how nascent this is at this time, but we do plan to forward out some practice advisories that come out just to make sure everyone has access. There's a couple initial posts that we've seen, like Ayla's had some good ones that we can share. If you have seen helpful resources that others could benefit from, send them over. You can send them to any of us directly. We can distribute those. Rex Chen's asking, will this scare immigrants applying affirmatively for benefits? They may worry that long-respected USCIS policies could be overturned if DHS one day argues there's no Chevron deference. Rex, do you have any interest in coming off mute to talk about that? We don't do that much USCIS work, so I'd love to hear your perspective on that.
Sorry, I'm just thinking about it, but thinking in vague terms, I don't really have analysis on it. I just know that there are a lot of great interpretations of USCIS policies, and I've heard in theory, should we be worried about that?
Yeah, I think it's a great question. I think there's been some things that have been pointed out, specific ones like, are there good things, right? Are there good things in immigration, normally USCIS, right, that are now vulnerable to challenge? I think in theory, yes. I think it's going to be more difficult to challenge those just procedurally. But, like there's some favorable interpretations about eligibility for work permits, for example. And like, could those be challenged by a conservative state? Maybe. But I think overall, of course, not to minimize that, it is really important. We should think about it. But I think we have to the extent we're weighing, right? Like we have more of the upper hand with Loper Bright being overturned versus the downsides, I think, in the immigration context.
Okay, well, we have covered our points. And does anybody have any final things they want to raise to the group before we wrap up? Give you guys a few more minutes of your time back.
Adina, can I speak to some of the PSG questions that have come up in
Oh
the chat?
yeah, please do.
Yeah. That's an issue that's an area of the law that's been of particular interest to me. And I do think that the three-part framework that the BIA is currently using for PSGs is vulnerable to attack because particular social group is an ambiguous term or has been recognized as an ambiguous term. And because of the ways that the BIA added particularity and social distinction after relying on just immutability, the immutable characteristic for decades. And I think that there's already been a lot of good litigation about how unreasonable that the addition of those two elements was back in 2008, 2012 originally. And the way that especially like particularity and social distinction kind of cut against each other, right? You have to be narrow enough with your particular definition of the PSG in order to satisfy particularity, but then on the other hand, it has to be a broad enough group that it's recognized as distinct within society. And the basis for adding those elements was kind of invented not entirely out of whole cloth maybe by the BIA, but it's certainly something that would be subject to judicial review, I think, under something like a reasonableness standard, like Lori was mentioning. So just that there was a question about whether there might be a risk of attacking that framework, trying to go back to immutability, whether there might be something worse that could come out of the federal courts. And I'm not sure that there would be. I think that I don't think that a federal court would necessarily be able to or inclined to like invent a different definition. I think at worst we'd probably be left with like the current definition, but I think there's space for us to push back against particularity and social distinction as additional requirements in favor of returning to the original most important element of the immutable characteristic for PSGs.
Thank you, Evan. Really appreciate you jumping in with that. It was super helpful to hear. And then we also just want to mention our upcoming roundtables to wrap things up. So speaking of Evan, he's going to be presenting the next one to share about some really incredible work he's been doing challenging inkle monitors. We've done our first few habeas petitions challenging the prolonged use of inkle monitors that have been successful. And we are about to be filing a petition for rulemaking to change the regs around alternatives to detention. So stay tuned for that. August 1st will be our next one coming up soon. Another ones we're thinking about for the rest of the year are listed here. Thank you all so much for joining us, and stay in touch. We'll see you August 1st, hopefully. Take care. We appreciate your time. Thanks, everyone.